Good morning, ladies and gentlemen. It's my pleasure to welcome you to our webinar on Free Trade Area Tariff Benefits, Impact of the 2020 Customs Amendment. Today, we are truly fortunate to have with us Mr. Vikram Nankani, who is a stalwart in this field. Mr. Vikram Nankani is a senior advocate. And I also have with me Mr. Shammi Kapoor, who is our partner. Mr. Vikram Nankani and Mr. Shammi Kapoor, it's truly my pleasure to have you here. We'll start soon with Mr. Nankani's presentation. I'll share the screen. And before doing that, I would request you all to keep sending your questions using the go-to control panel. We'll endeavor to take them towards the end.
Yeah, thank you for inviting me and making me a part of this webinar. These are times where people will use it effectively to learn new things and, of course, unlearn a few other things which we did not have to face during the normal times. This topic that you've chosen today is not one of those run-of-the-mill topics and pretty unusual, but at the same time, something which is extremely important and will affect business and trade and commerce once normalcy comes up. It certainly is a major change in the law which has been introduced and probably has gone unnoticed by a large section of the industry. And its ramifications are going to probably affect everyone at the larger, in the largest sense, because it does not only deal with the inter-party rights and obligations, but escalates it to a level where it is the national issue and a treaty involving two sovereign powers, how those treaties will be treated in that sense vis-a-vis the law that has been introduced. With that little preface and background, let me just start with the historical perspective, which is in the next slide, as to where is this all coming from? What is the genesis of the new proposed amendment in the Customs Act, which has been brought about in 2020, which is the core area of discussion today. Can we go to the next slide, please? So I've divided the discussion today into four parts. The first part is, of course, the historical perspective. Free trade agreements are not something which is the only form of international obligations or treaties that India enters into. And if we look at it, there are such similar bilateral treaties in different areas, such as the direct tax, where we have the double taxation avoidance agreements. Sorry, I'm a little technically handicapped. I'm not so savvy. So may I just request that somebody, my presentation is being shared. So yeah, could we go to this slide, please? Just one slide before this. So there are double taxation avoidance agreements, which India, everybody knows, have been historically in vogue. And while we did see a landmark judgment of the Supreme Court in the context of such double taxation treaties, which is popularly known as Union of India versus Azadi Bachao Andolan, where the challenge was to the acceptance of the tax residency certificate issued by Mauritius government. And certain self-proclaimed patriots challenged that treaty to say that this treaty is being abused, it is being used for other clandestine purposes by setting up shell companies in Mauritius and routing the investments through Mauritius. Supreme Court mercifully in that case had dismissed the petition and held that the sovereign's right to enter into treaty is absolute. And once the sovereign decides that this is the arrangement or the relationship that it will share or enjoy with the other country, then that has to be respected by each of the countries. It's like a sovereign contract. So that was the context of the Azadi Bachao Andolan. But yet we saw a few years back when the India-Mauritius Treaty was tweaked in a manner that it virtually uh, took away the large essence of the earlier treaty and the broader liberalized approach which was there in the earlier treaty, and almost nullified all the effects of the double tax treaty with Mauritius. Obviously, the reasons given were OECD, um, taxing of or discouraging tax havens, etc., etc. But the net result was that India did go back on its earlier commitment and did introduce new restrictions, new covenants in the India-Mauritius Treaty. This is not an isolated case. We have seen such an approach of the government of India even in bilateral investment treaties. Uh, yes, India is not a party to the ICSID. So at the multilateral level, we are not parties to any investment treaties. But India does have bilateral investment treaties with each of the countries, with many countries that it has chosen to do so. Sorry, as far as I can see, the slide is slightly different on what you're seeing it. I think it will have to go to the next one, please. Um, the historical perspective that I was getting into. So let me continue with the bilateral investment treaty. We saw that even in bilateral investment treaty, there has been a clawing back of certain commitments which India has been historically making. And a great example of that is the case of white industries versus the government of India. For those who are not aware of the background of this case, this is a case which arose out of arbitration, where White Industries, a mining company in Australia, had filed an arbitration claim against Coal India Limited, a PSU. An award was passed in 2002 against Coal India and in favor of White Industries. From 2002 to 2010, White Industries was running from pillar and post to recover the amounts which were awarded to them. That was not happening. So White Industries instituted a second arbitration, this time under the bilateral investment treaty with Australia, and said that the government of India must be held responsible to the investors in non-honoring of the awards in favor of the investors. And it is at that stage that the second arbitration also resulted in an award against the government of India, saying that there has been a breach of bilateral investment treaty. And although this was a transaction which emanated out of the dispute arose out of a transaction between White Industries and Coal India Limited, that was regarded as an investment into India, and that then fell within the terms of the bilateral investment treaty, and of which India was held to be guilty of. And the second award also went against the government of India. It is at that stage that everybody rose to the occasion to figure out what happened, because until then, nothing had hit India so hard in terms of bilateral investment treaties. And then what we saw that, or the knee-jerk reaction to that was that in the current avatar of a model BIT, which you will find in public domain, you will find that most of the clauses today are almost one-sided in favor of India, with a large number of exclusions to the fair and equitable treatment policy, which is the heart of any bilateral investment treaty, which is the minimum assurance that you give to an investor who comes and invests into your country. So we have seen that the model bilateral treaties are today tilted in favor of India. So a common trend which has been seen over the last 10 years or so has been that India has tightened the noose in all its bilateral treaties, whether it related to tax or whether it related to investments. And now we see another great example of this happening in the context of free trade agreements. Um, as we all know that India is a signatory to the WTO agreement. The World Trade Organization is the global body which regulates or which lays down the guidelines of trade, international trade and commerce. Sorry, this is the next slide, please. Being a signatory, there are to the WTO, there are certain exceptional situations in which the sovereign who is a signatory to the WTO agreement can have its own clauses for the national protection purposes. Those are the limited situations which are captured in the WTO enabling clauses, in clauses 4 and one read with 4.1. And if you read that, it says that it may, in certain situations, withdraw the differential or the favorable treatment, provided it notifies all the contracting parties and it affords an adequate opportunity for prompt consultations at the request of any interested contracting party with respect to any difficulty or matter that may arise. And then it also provides that the contracting parties shall, if requested to do so by such contracting party, consult with all contracting parties concerned with respect to the matter with a view to reaching solutions satisfactory or to all such contracting parties. Therefore, the global commitment is that yes, I will give you favorable trade treatment. I will give you I will give you I will give you trading rights with citizens of our country. If I, however, want to change or withdraw the benefit or the favorable treatment, I will do so by a consultative process. This is the commitment which India has made to the World Trade Organization. Has this commitment been lived up to? Is the question which we will ask ourselves when we go into the recent amendment. I'm just now laying the foundation for critically examining the new amendment which has come about. So, what are the typical ingredients of the free trade agreements that we see today? Today, we have a number of free trade agreements with our neighbors, the SAARC countries, the ASEAN countries, and on an individual basis with various other countries which are bilateral. So we have both multilateral free trade agreements as well as bilateral bilateral free trade agreements. Typically, these agreements have a benefit for both countries in terms of trade involving the countries which are parties to these treaties. In short, what it says is that if there is any export from one of the contracting states to the other, to a person of the other contracting state, then subject to certain value addition norms, there will be certain tax benefits which will kick in. The tax benefit could be zero, which could be wholly exempted, or it could be partial, depending upon the terms which have been negotiated between the two contracting countries. That's not so much of a problem. It's not that every free trade agreement must result in a total exemption from payment of customs duties upon import into India. So the key part is the value addition part. And that is where they define that in certain cases, the value addition could be 25%, and in certain cases, it could be 35% of the value addition, depending upon the origin of the products which are being imported into India, depending upon the origin of the raw materials or inputs used in the manufacture of goods from the exporting country, which is a signatory to the free trade agreement. Now, all this has again been provided with a mechanism. It's not that the value addition requirement or the criteria has been put in vacuum or has not been translated into a mechanism. There is a full-fledged mechanism, and the mechanism is that the importer will bring a certificate from the competent authority of the original country of origin, and that person, the importer, if he produces a certificate from the competent authority of the exporting country, then that is final, conclusive, and binding in normal circumstances on the importing country. And that is the mechanism which is typical in all such cases which are regulated by the treaty. And the certificate of origin, there's a prescribed form for the certificate of origin. The certificate of origin also, the treaty also identifies who is the competent authority of the exporting country, who needs to certify that. So the name of the competent authority, the form in which the certificate has to be issued, all of them are prescribed and part and parcel of the rules of origin and the treaty. So nothing is left to chance. And once an importer who is a buyer of the goods as far as the seller in the other exporting countries concerned, his obligations are discharged the moment he brings the certificate. There is plethora of case law, and it seems to be today the final word on the subject, that a certificate which is produced is, as I said earlier, binding in the sense that the Indian authorities cannot go behind the circular and cannot sit in appeal or judgment over that circular, or cannot challenge it or question that circular at the micro level of the officer concerned, who is examining the goods, who is making an assessment on the bill of entry, and who is ultimately passing an out of charge order under the Customs Act. Now, at that level, therefore, it is unimpeachable. But the treaties do provide, and that is also part of the treaty today between India and its other member countries, is that if there is any scope for doubt or for examining the validity or the genuineness or the authenticity of the certificate, then there is a provision in all treaties to deal with such a situation. It calls for a bilateral discussion, dialogue, and verification and inspection, where one country which is suspecting the genuineness or authenticity of the circular can raise it with the competent authority of the other member country, and at that level there will be an investigation and an inquiry. And if the result of that investigation or inquiry conducted by the exporting country is not to the satisfaction of the importing country, the matter can be referred to arbitration. So the dispute, if any, arising between two countries out of the treaty itself has got a further remedy, and the remedy is in the form of arbitration or dispute resolution mechanism. So all the treaties are, in a sense, self-contained codes, and they have a full-fledged mechanism of what are the qualification conditions, namely, as I said earlier, value addition, in certain cases 25%, in certain cases 35%. And those certificates, the efficacy of those certificates, if they have followed the prescribed procedure and the prescribed form, the legal effect and the binding nature of those certificates. And finally, if there is a dispute with regard to those circulars, the dispute can be handled in a particular manner as provided for in the treaty itself. So this is the lay of the land as far as the present situation or the present treaties are concerned. Now, as I said, there is ample case law which is available on the subject of how India will deal with its treaty obligations when it comes to any perceived conflicts with the national law. Uh, Article 51 of our Constitution, which is part of the Directive Principles of State Policy. These are contained in Part 4 of the Constitution of India. Article 51 provides that India, as a sovereign, will enter into international treaties on various subjects, and those treaties will have to be honored and respected. Now, what it really means, Article 51, as I said, since it falls into Part 4 as Directive Principles of State Policy, we all know that those provisions are not legally enforceable, in the sense you and I can't go to the writ court and file a petition in the High Court or the Supreme Court to say that there is Article 51 and India doesn't seem to have a bilateral agreement with, let's say, X country or Y country, and since I want to do business with that X country or Y country, India should enter into a bilateral treaty with that X or Y country. That can't happen. That is the meaning of its unenforceability. It should not be mistaken with unenforceability once the treaty has been signed and once the treaty is in force. So Article 51 is an overarching enabling provision which the Constitution has conferred upon the Parliament to make its national laws in sync with and align the national laws with the treaty obligations which India as a sovereign may enter into. Given that constitutional background, if we look at some of the Supreme Court key decisions, there are many, but we've just picked up a few because the discussion is not on the judgments part, but on the current amendment. So if you look at the first case on the slide was Gramophone India, which was a case which arose under the Copyrights Act. And here was a situation where certain pirated copies of videos or CDs in those days was being imported into India and taken to Nepal. Nepal, we all know, is a landlocked country, and therefore imports come through the sea route into India and from there travel by land to Nepal. And the Indian customs sought to take action, saying that this is in breach of the copyrights law and IP rights which the persons concerned may enjoy. And notwithstanding the fact that the goods were actually meant for Nepal, because India is committed to protecting IP rights and because India will not encourage trade in pirated stuff, Indian courts upheld India's power to deal with those pirated goods, confiscate them, and take whatever action they could do in accordance with law. So that is the length and the breadth to which the Supreme Court said is India's obligation in the international sphere. Azadi Bachao Andolan is the judgment that I referred to earlier, where the Mauritius Treaty was challenged. And while quoting from this celebrated book of Bennion on interpretation of statutes, the Supreme Court has once again reiterated and hammered the point that when it comes to interpretation of treaties, which are negotiated and entered into at the political level, and several other considerations are followed, such treaties will have to be honored and given full effect to. We also had a case thereafter under the anti-dumping law, and this was a case of Commissioner of Customs versus GM Exports, which was as recent as 2015, where the Supreme Court, while dealing with the anti-dumping law, said that in a situation where India is a signatory nation to an international treaty, a statute is passed pursuant to the said treaty, it is a legitimate aid to the construction of the provisions of such statute that are vague and ambiguous, and one has to take recourse, therefore, to the treaty to resolve the ambiguity, if any. And the result of that ambiguity will be that an interpretation which is consistent with the provisions of the treaty will prevail. So, as we all know, that under the anti-dumping law, there are anti-dumping section 9A of the Customs Tariff Act deals with anti-dumping, and pursuant to that, there are certain rules also made for determination of the whether there is dumping, whether there is injury, what is the injury margin. And the Supreme Court therefore said that if you have entered into a treaty, then the treaty is not just a pious hope or something which remains on paper. It is a treaty which will thereafter have a very significant role, even in the interpretation of the domestic law. And if there is any conflict or any ambiguity or any vagueness, then any interpretation which has to be given to in such a situation will be in favor of the treaty and the implementation of the treaty. With that background, having spent considerable time in the background, let's straight away now dive into the new provisions which have been introduced in the form of Chapter 5AA under the Customs Act. To be precise and get more technical, it is a new section, Section 28DA, which has been introduced, specially addressing or dealing with questions relating to preferential rates of duty where any such claim is made under or by virtue of a trade agreement. Now, if we look at the plain language itself, it is pretty scary. If we see, what it first provides is that the claimant of this benefit of the preferential rate of duty is making a declaration that the goods qualify as originating goods for preferential rate of duty under such agreement. I asked myself the question, why do I need to make this declaration if I have the certificate which has been issued by the competent authority in the prescribed form? There is, that by itself is a declaration that the goods qualify as originating goods, and therefore any such declaration from my end or from my side is not going to have any additional benefit as far as the assessing officer is concerned. It is India's sovereign commitment versus my declaration to a proper officer, an officer who is exercising his powers limited to the extent they are vested under the Customs Act. And mind you, that I would reckon that in India, at every port, there would be multiple proper officers. And if you look at on a pan India level, we are talking about the personal satisfaction of a declaration being made to about 1,000 proper officers who potentially can have 1,000 different views, and that is the magnitude of this disproportionate power that has now been given to say the declaration to be made by me. The second condition makes it worse. It says that possess sufficient information as regards the manner in which the country of origin criteria, including the regional value content and the product specific criteria specified in the rules of origin in the country in the trade agreement, are satisfied. Shorn of all the legal jargon that has been used, simply put in a layman's language, what it means, if tomorrow the officer tells you, show me how have you calculated 35% value addition, you as the buyer of the goods must give me data. You as the buyer of the goods, as an importer who's claiming the benefit of the treaty exemption or paying the preferential rate of duty, you must tell me how you have met with the value addition criteria of 25%. Or you must first tell me why have you calculated value addition at 25% and not at 35%. Now, all these, the entire burden is now shifted upon you, meaning thereby that the entire mechanism in the treaty has been given a go by. It's thrown out to the winds. To say, when I mentioned to you earlier that the treaty has a full-fledged mechanism for dealing with cases where at the country level, not at the individual level of a proper officer, there is any doubt about the veracity, the authenticity, or the genuineness of the certificate, you can escalate. It's not as if the government is helpless and will encourage a fraud, nor will the other contracting party encourage a fraud. But that doesn't mean that you will shift the onus on a person who has no privy to this information and data. Even if I want to comply with this provision of law, I cannot, which really defeats and goes against the grain of a fundamental axiom of law, which is that the law cannot expect a person to do the impossible. Which seller in his right mind is going to tell you how much value addition he has done, because that is revealing all trade information, confidential data as to what is his margin of profit, what are the sources of his raw material, what is his purchase price, what is his value addition in terms of production cost, and all that information and data. He is going to tell you in plain language, shut up, I am giving you a certificate of the competent authority. Beyond that, you have no business to ask me for anything merely because your country has put in a legal provision asking you to disclose this data. You are doing business with me on the basis of the treaty. The treaty has certain conditions. I am complying with those conditions. Once I comply with those conditions, then beyond that, I have no obligation to share any data with you. It's like walking into a sari shop and asking the seller of the sari shop at the sari shop as to what is the cost. Why are you charging me 1,000 rupees? Please explain to me, give me account of every rupee, of every paisa that goes into the formulation of rupees 1,000, which is the price, tag price of the particular merchandise or the garment. It is as as ridiculous as that. If I can't do vis-a-vis a small trader and a shopkeeper in India, how do you expect me to comply with this merely because you have the enthusiasm of collecting revenue? It is a backdoor method of nullifying the treaty. If you have the gumption as a nation and you want to tell your trading sovereign partner to say, I do not want to respect the treaty that I have entered into with you, I want to walk away from the treaty which I have entered into with you, I will and if you can't do that, then this certainly is the most, if I may say, absurd form of entering into a backdoor formula to say, with one hand, I have had an international face by showing that I am a global player, that I respect global business and trade, that I know that there are larger interests of the WTO, but at the micro level, I am going to take away the benefit, and at my national level, I can protect my interest of revenue. There are no guidelines. It's a mandatory condition. It says shall. The declaration is such that shall, and I must possess this information. And three, I must furnish such information in such manner as may be provided by the rules. And that I must take reasonable exercise and care for the accuracy and truthfulness of the information furnished. All these are conditions which are impossible of performance. Now I know that something must be said in defense of the government also. The government is going to throw at us a large number of cases where people have fraudulently taken the benefit. It's not lost to any of us that there have been cases where there have been investigations which have been conducted to show that goods imported from X country, let's say Sri Lanka, Indonesia, Malaysia, are far in excess of the total production of that particular item from that country. I can understand the anxiety of the government of India on that account. Or that there are some cases where the value addition norms, the accounting standards of the exporting country are very different for determining the value addition as far as the true value content is concerned. And India may not agree to those differential accounting standards of those particular country. But then address it at that macro level. Please do not introduce a mechanism or a tool in the hands of a proper officer which will result in nothing but harassment and will result, I dare say, in negating the treaty benefit altogether in almost all cases, because you have vested the officer with such powers which are draconian and which are not discretionary but mandatory to be followed. In such a situation, you have to deal with it at the level at which you have entered into the treaty. If there are concerns, we are not, no one's holding out a brief for fraudulent importers. Nobody is holding out a brief where people resort to the violation of the law and try and circumvent the law. There is no room for that. But then that is a separate school of thought. There is a separate line of cases for that, that a fraud benefits nobody and a fraud nullifies everything. The whole transaction comes to a naught. Certainly, nobody will object to actions being taken in such cases where you find that ex facie there is a fraud, and you then raise it at that level. But to introduce a general provision which will capture all, and it's a catch-all provision, that such a kind of a provision will really result in misuse and abuse of powers and will really nullify the treaty. It's like in one hand, in one shot saying, I hereby terminate the treaty because my proper officer, who is the lowest officer in the administration of the assessment machinery, has now the power to rewrite the entire treaty by asking for such information and data. In fact, this also goes against the basic principles which are enshrined under the Evidence Act. Now, I must hasten to add that Evidence Act per se does not apply to any customs assessment proceedings. I mean, there can't be any argument on that, and I can't be faulted by for referring to the Evidence Act for this purpose. But The principles contained in Evidence Act would certainly apply to all quasi-judicial proceedings, and an assessment of customs duty is held to be a quasi-judicial proceeding. Now, even under the Evidence Act, there are provisions which say that a person is only obliged to divulge special facts, mind you, the emphasis on the word special fact, which are to his exclusive knowledge. Now, my importer or an importer in India has no knowledge at all, much less exclusive knowledge of the special facts that go into the determination of the rules of origin criteria, or the value addition, or the manner in which the certification is done by the proper officer. You can make an inquiry and ask whether this has been actually issued by the competent authority. If the answer is yes, it is at least the first, you can tick the first box that it is authentic and it's not forged, or it is not it's not bogus certificate, because again, forgery is nullity, renders everything null and void ab initio. That's also been held in many cases, including in customs cases in 1961. And thereafter, the second inquiry could really a situation where the value addition norm has been met, and that can be an inquiry conducted in terms of the treaty. And at that level, again, if there is a difference of opinion, you refer to the arbitration. You refer it to the arbitration. But leaving it to the reason to believe, and that's the next slide, because that's the only criteria which the law has put in as far as the proper officer is concerned, that he believe that the certificate of origin is not genuine, he may ask the importer to furnish the information. Now, the words reason to believe have been judicially dealt with in number of cases. And once again, it has been dealt with across the board in the context of various laws, whether they are commodities laws, whether they are confiscatory laws like the Essential Commodities Act, or whether they are tax laws like the Income Tax Act, or for that matter, the indirect tax laws. The word reason to believe have been held judicially to mean a subjective satisfaction. The officer concerned need not have conclusive material against you to say that this is a case which will lead to ultimate conviction, or will lead to ultimate proof of guilt of the party concerned. So it is very wide, and it is pretty nebulous. So when you say reason to believe and it involves subjective satisfaction, it means that even a drop of the hat, the officer concerned can on his own make some research, go to Google, go to unauthenticated data sources like Wikipedia, make some note for himself and say, now I have reason to believe that this certificate of origin is not genuine, and therefore you must now satisfy all the conditions of declaration and the data furnishing of the data as to the rules of origin criteria. And then the importer is then required to provide all the information. And if the proper officer has a reason to believe that it is not genuine, the immediate action that he could take, he could temporarily suspend the benefit under the treaty. Mind you, he can temporarily suspend. In other words, he may ask you to furnish a security or deposit certain amount equivalent to the duty which is payable but for the preferential treatment, pending the final verification or the final investigation. So this is the level to which the officer can go, and the powers which are vested in him will mean that as part and parcel of your condition of clearance of goods for home consumption, you may be asked to give a bank guarantee, you may be asked to give a bond, and worst of all, you could be asked to deposit the amount in cash, either full or part, depending upon the whims and caprice of the proper officer. And upon such temporary suspension, then the officer will thereafter post facto inform the authority in the export country and seek information. Now, I can understand that if you want to seek information, you do it at the highest level. I can understand. But as I said, 1,000 proper officers all over the country in all major and minor ports and ICDs and the CFSs which are handling cargo. Can you imagine that at that level, if an officer was to send an inquiry to the issuing authority in the exporting country, what would be the fate of collecting of that information, and what would be the time that would be lost, and how long will you keep renewing the bank guarantee? This should have been done at the highest level, assuming that you had any anxiety. There is already a treaty provision. Why you want to duplicate and now create a parallel machinery which is not in sync with the treaty, and give that wide, unbridled, unguided power to the proper officer to seek an inquiry with an issuing authority? And till such time, your assessment will continue to be temporary or provisional. Once the information comes, the proper officer will then decide whether he is satisfied with that information or not. If his satisfaction as a proper officer is adverse, the proper officer will record reasons and permanently deny preferential treatment. So now you know who's the lord and who's the master. The proper officer can sit in judgment over the competent authority's view, even though that competent authority is discharging treaty functions and has the sanction of a sovereign function. And this is where really the entire emphasis has got misplaced. Not only that, what it has to be, what is further provided is that notwithstanding anything contained in this section, the preferential tariff treatment may be refused without verification in certain circumstances. Where the tariff item is not eligible, yes, I can understand. But who's going to decide those classification issues? There will be and may be cases of difference in the classification. The exporting country may classify it in a particular head. The importing country may classify it into a particular head. I am not saying that such conflicts should not be resolved. By all means, resolve it. But please do not condescend to this lowest level of saying that a proper officer will now become the mediator or the arbitrator who will resolve these differences in the tariff item, where the complete description of goods is not contained in the certificate of origin. What is complete? Is a reference to a serial number or a model number or a brand number of the trade number not sufficient? Is there somebody may say no, this is a market description, he should have given a technical description. In chemicals, he should have given the full chemical formula. So what is the complete description? Any alteration in the certificate of origin is not authenticated. I can understand the treaty itself has got provision for that. So therefore, you are not trying to cover up here by giving this or reiterating this in the statute book. And the certificate of origin is produced after the expiry period. That these are, yes, you have put it in the mix certain things, uh, which were otherwise covered by the treaty. But in the garb of putting those two things, you have also added a few more extra items which really do not justify your the presence under the Customs Act. So the only saving grace probably is, and this is again, I mean, I'm using the word saving grace euphemistically, because in any case, the limitation of 5 years within which the officer can call for information with regard to preferential treatment is already part of the condition under Section 28, whereby any short levy or non-levy, even in the most extreme cases of willful misstatement or suppression of facts, is confined to 5 years. So this is nothing new. It is again a rehash of the same thing in the specific provision with regard to preferential treatment. So the net result that we come to is this, that all the case law which says that India as a sovereign must respect its treaty obligations, and the constitutional mandate which has been given to say that India will enter into treaties, are all sought to be put to rest and converted into a knot by virtue of these provisions. They render them susceptible to challenges. I will not be surprised if those challenges are upheld. But for the moment, till such time, at the moment these provisions are put into play, they would result in a serious disruption of trade and commerce. I don't know whether the trade and disruption will add to the confusion which is already caused by the current virus and the pandemic. On one hand, India seems to be taking a lot of measures to massage the hurt of business disruption by various packages announced by the Reserve Bank of India, by the various regulators that has been that are in, that deal with trade, business, and commerce, by even introducing amendments and ordinances in insolvency laws or the restructuring laws. On one hand, they seem to be saying that we will do everything, go all out to ensure that there is ease of business, smooth trade and business continues even after the virus has disappeared. But on the other hand, use this very time when people's attention is focused mainly on trying to survive and revive. And in these testing times where people are looking at surviving and reviving, these amendments have been introduced so very surreptitiously. In that sense, a strong word I know that I'm using, but which really has gone under the radar and has not been noticed. Or on the other hand, is this one more case where you say that I am not concerned with my international treaty obligations? I am more worried about Atmanirbhar, and this is one more step towards ensuring that India and India alone looks inward, and the treaty obligations will take a backseat to Atmanirbhar. That's all that I have to say. I'll be happy to take questions, and I think they would be on the chat group, so happy to take the questions. Thank you very much.
Thank you, Mr. Nankani. That I can say on everyone's behalf, that was an extremely enriching presentation for all of us. We have come across a lot of issues now, and if I had like 3 questions before, now I have 5. So probably I'll start with questions, but before that, we can have Mr. Shammi Kapoor with his remarks. Mr. Kapoor, I request you to keep it short as time is we are running out of time soon.
Thanks, Arnab. Excellent. I must compliment you, Mr. Nankani, for bringing out the different nuances which have been brought out in Chapter 5AA, more specifically in relation to the new inserted Section 28DA in the Customs Act. Frankly, I don't think there is much else to say apart from the fact that the law is draconian in nature. And while I was listening to your presentation, I was asking a question to myself, whether these FTAs, free trade agreements per se, are reaching a death knell on its own by virtue of these amendments, the newly inserted chapter which has been brought out in under the Customs Act. Well, but the answer is a mixed answer. While I was asking that question, I was also trying to figure out what could be the answer. As you rightly said during the presentation, that as India, as we all are surviving and trying to revive our businesses, and the government of India's main intention as of now is to make an India policy. I truly believe, as part of a Make in India policy, because of certain ill effects of many of these importers, I think the government of India was forced to bring about these amendment in Chapter 5AA by inserting this section. More so because of, I personally believe, if you go back to 2015, when SIT was formed by Supreme Court in relation to black money, it was also found in that SIT by that special investigation team of Supreme Court that there was a lot of money tripping happening in the garb of these FTAs, and therefore these matters were then referred to DRI, who then came out with their own reports, and which have actually culminated into these present newly inserted section, which in some ways are of course draconian, because there is an undertaking which is required to be given, there is a declaration which is required to be given, and then above all, it is of course subjective as there is, it is all depends upon the proper officer of the customs to come out and see whether he has any reasons to believe it otherwise, that the certificate of origin given by the exporting foreign exporting country has some different norms to follow, or is it a rerouting of goods by non-signatory countries through the signatory countries who have FTAs with India. Needless to say, then thereafter there was the judgment of Mumbai High Court, which also traveled to Supreme Court in case of purple goods, wherein Mumbai High Court had given wide powers to customs authority, that they could have gone beyond and do the investigation or carry out the investigation in whatever form they want. And then importer went to Supreme Court. Supreme Court said that they could not have two different lenses in relation to these kind of imports which were under FTA, where a certificate of origin was already given by the foreign exporting country. Now, having said that, of course, I truly believe I'm a nationalist, frankly, but having making a statement that I'm a nationalist, I also know that these FTAs also have their own pluses and minuses. So I was asking another question, whether it does not violate the doctrine of pacta senta servanda, which is doctrine of trust and faith between two countries when they have entered into FTAs, or maybe a multilateral agreements that they have entered, say between India and ASEAN countries or many other countries. And but having, when you go through all these FTAs and the recent development that has come about, I think the intent of Government of India is to give more impetus to either export or to import from those countries which are more, having the source of goods which are coming into India either through value addition of 25% or 35% as the case may be. Say a country like South Korea or a country like Japan, where India is more friendly, but whether they would also be under these kind of scrutiny or investigation, or whether it is only specifically targeting China per se, because if India was to sign RCEP way back in 2019 in November, then it would have actually resulted into more dumping of goods from China and other countries into India, and thus resulting into more import or foreign exchange flow out of the country rather than there being any export into the country, export from the country. With these remarks, I think we need to really dwell upon that the nature is draconian, definitely, and excess power of delegation has been cast upon these customs authority, and whether their subjectivity is going to be positive or negative, we need to see. But we all know that it is more negative rather than being positive, and whether there will be any misuse of power in the garb of these present amendments having been brought out by the under the Customs Act. Thank you. And also, I just thank you very much, for the wonderful presentation that has been brought up by you, sir.
Thank you.
Mr. Alkani, we can take a few questions now.
Yes.
The first question I have is, how do you see this going forward? Do you see that there is an opportunity for kind of a representation to the government for softening certain provisions, or do you see the writ court as the only option?
No, certainly, I think there is a scope for making representations to the government. This can be done by national trade associations or bodies because they will bring out the practical aspects. As Mr. Kapoor rightly said, that there are always two sides to the coin. The government will like to have its own concerns also being brought into the mix. So an SIT reference is of course one such case where from that judgment of Ram Jethmalani, black money resulted in the SIT, and the SIT income tax department did give a report. So everything is capable of being misused. How do you plug those loopholes is one part of the concern, but the presumption in law is that the law is made for the genuine people. The mischief rule undoubtedly is there, is a recognized rule of legal weaponry. that you use legislation to plug the mischief. But at the same time, it can't be a situation of throwing the baby and the bathwater out together. Genuine business concerns have to be are paramount, and it's only the exceptions which are in the nature of fraud. We know of cases, as I said earlier, also in the presentation, that there have been instances where people have brought in country goods from a country far in excess of the total production of that country's of that same goods. In fact, that country is a net importer of that same goods, has been proved in some cases, and yet it claims to be exporting under the treaty a large number of quantities to countries such as India. So there is no denying the fact that the government will have its concerns. And it is exactly for this reason that a reconciliatory approach of the trade and the government must be there. Because if the trade wants to avoid the draconian effect of the legislative amendment, then the trade must also come with solutions as to how do you plug the loopholes, how do you plug the without disrupting genuine businessmen. And this can only be achieved through representation.
So, I have two more questions, and then probably we can conclude. The second question is, if this is indeed the new normal, what kind of legal obligations do you think would have to be put on the exporter, especially in cases of, say, related parties? We have a lot of cases where companies in India import from related parties in Bangladesh or Vietnam. What kind of checks and balances, what kind of rewriting of uh, uh, agreements do you see going forward?
So, as we know the basic principle of every contract is that it must commensurate with the law of the country. And so, therefore, the contractual contours will have to be reset. New provisions will have to be added, more so in the case of RTP, where the party on the other side of the border is related, the obligations of disclosure would be more enhanced. And you will have to revisit your contractual agreements and rewrite them to factor in this kind of information. Again, the government may say that if it is a genuine situation, why are you worried or scared about disclosure? And of course, the answer will be that we do not trust that this information will not go out in public domain. So even if a related party was to share information, the related party will ask for indemnities and will ask for confidentiality to be maintained once they disclose this information. And that is why it was kept earlier in the treaty at the highest possible level, which we have also seen exchange of information under the DTA. So if you keep it at that high level, there is a presumption of confidentiality being maintained. At the micro level, how that will be addressed, I think there will be pressures on both sides. The seller will always ask for certain protections of data from it being divulged and confidentiality being maintained. Uh, in fact, as Mr. Kapoor mentioned about that purple case, I was privileged to appear both before the High Court and the Supreme Court in that case. And while the High Court passed the buck on to the adjudicating authority, the Supreme Court did realize that this is something which only the courts can decide and not the administrative machinery. And I adopt the same principle that when these seminal questions of jurisdiction are decided, the rights and obligations of the parties are decided, it has to be done at the highest level. If instead of the proper officer, all these powers were vested with a higher functionary, maybe at the level of the CBIC, things would have been looked at little more differently by the courts, little more sympathetically towards the government. But reducing it at this level will mean that a lot of contractual arrangement has to be revisited.
Thank you, sir. The last question that I have, and we are receiving a lot more questions, but probably will defer it to email communication way of response. The last question that we have time for probably is that if you look at subsection 5 of section 28D, and I think you also touched upon this issue, that where there is a reason to believe the proper officer, or rather the principal commissioner, can escalate the matter and he can ask the differential duty to be deposited pending verification. Do you not believe that this is excessive and starkly different from the current situation where a BG or a bond would have sufficed?
So the law uses a generic term security, and that is where the discretion will play a large role. If I don't like your face, I may ask for cash deposit. If I know that you're in financial difficulty or in trouble, I may ask for cash deposit. If I think that you're a five-star importer or an exporter and you have a credibility and your antecedents are good, there have been no past misconduct or cases against you, I may be convinced that a bond would suffice. So I think that the Parliament has therefore consciously just left it to the ground level, to field formations to decide which case, what nature of security can be imposed.
Thank you, Mr. Ankari. That's all we have time for. So we have received few of your questions. As I said, we'll try to respond to those over email. I would go over to Mr. Kapoor for concluding remarks. But before that, sir, if you have any further concluding remarks, you can please go ahead, Mr. Ankari.
No, I must just thank you, Arnab and Mr. Kapoor and Vaish Associates for giving me this opportunity. I really love the subject, and as I said to you before the conference started, that it was the topic which really excited me to be a part of this webinar. Thank you again.
Thank you, sir. Our pleasure and our honor to be hosting you. I'll go over to Mr. Kapoor for his concluding remarks.
Sorry, can't hear Mr. Kapoor. He needs to unmute himself.
Am I unmuted? Am I audible? Yeah. So thank you, sir, for having it was great having you on board on this webinar, which of course is not one of those which you said in the starting that it's not run of the mill. And as rightly stated, because free trade agreements are one which needs more understanding of the subject. And as you are one stalwart in indirect taxes, it was great to have you today. And we expect to hold such more webinars with you in future as well, sir. Thank you once again from bottom of our hearts, sir. Thank you.
Thank you.
Thank you, sir. Good day, everyone. We'll come back to you with probably more such enriching topics. Take care of yourself. Good day. Bye.